The Constitution of India was amended in the year 1951 by the Provisional Parliament, which inserted Article 31A and 31B to the Constitution in order to save certain enactments with respect to acquisition of estates in order to abolish the zamindari system. Certain zamindars challenged this first constitutional amendment by preferring petitions before the Supreme Court, declaring the First Amendment to be unconstitutional and void. The main arguments of the petitioners were first, that the power of amending the constitution was conferred on the two houses of the parliament as a designated body, and therefore the provisional parliament was not competent to exercise that power under Article 368 of the constitution. Second, the Amendment Act violated certain fundamental rights of the citizens and therefore falls within the prohibition under Article 13 Clause 2 and therefore was void. Third was that the newly inserted Article 31A and 31B took away the powers of the High Court and Supreme Court to examine the validity of these enactments and therefore took away the power of judicial review and altered the basic structure of the Constitution and therefore were unconstitutional and void. The Supreme Court examined the provisions with respect to the provisional parliament, which were provided under Article 379(1). Article 379 of the Constitution provided that until both the houses of the Parliament have been duly constituted and summoned, the body functioning as the Constituent Assembly before the commencement of the Constitution shall be the Provisional Parliament and shall exercise all the powers and perform all the duties conferred by the provision of this Constitution on the Parliament. The Supreme Court examined the provisions with respect to the amendment of the Constitution and held that the power and procedure to amend the Constitution is provided under Article 368. The Constitution provides for three classes of amendment of its provisions. First, those that can be effected by a bare majority, such as that required for the passing of any ordinary law. The amendments contemplated in Article 4, 169 and 240 fall within this class and they are specifically excluded from the purview of Article 368. Second, those that can be affected by a special majority as laid down in Article 368. All constitutional amendments other than those referred to above come within this category and must be effected by a majority of the total membership of each house as well as by a majority of not less than 2/3 of the members of that house present and voting. And third, those that require, in addition to the special majority above mentioned, ratification by resolutions passed by not less than 1/2 of the states specified in Schedule A and B of the first schedule. This class comprises amendments which seek to make any change in the provisions referred to in the proviso to Article 368. With respect to the argument that the first constitutional amendment violated fundamental rights of the citizens and therefore was void under Article 13(2), the Supreme Court observed that Article 13(2), which provides that the state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. The argument was therefore that the state includes parliament and law must include a constitutional amendment. The Supreme Court, with respect to this argument, held that although law must ordinarily include constitutional law, there is a clear demarcation between ordinary law, which is made in exercise of legislative power, and constitutional law, which is made in exercise of constituent power. Supreme Court held that we find it difficult, in the absence of a clear indication to the contrary, to suppose that the Constitution also intended to make fundamental rights immune from constitutional amendment. We are inclined to think that they must have had in mind what is of more frequent occurrence, that is, invasion of the rights of the subjects by the legislative and executive organs of the state by means of laws and rules made in exercise of their legislative power, and not the abridgment or nullification of such rights by alteration of the Constitution itself in exercise of sovereign constituent power. That power, though it has been entrusted to Parliament, has been so hedged about with restrictions that its exercise must be difficult and rare. On the other hand, the terms of Article 368 are perfectly general and empower Parliament to amend the Constitution, without any exception whatever. Had it been intended to save the fundamental rights from the operation of that provision, it would have been perfectly easy to make that intention clear by adding a proviso to that effect. We are of the opinion that in the context of Article 13, law must be taken to mean rules or regulations made in exercise of ordinary legislative power and not amendments to the Constitution made in exercise of constituent power, with the result that Article 13, Clause 2 does not affect amendments made under Article 368. So, therefore, holding that the law as provided in Article 13 does not include a constitutional amendment, the amendments made to the Constitution cannot be challenged and cannot be held or declared to be unconstitutional as violating fundamental rights of the citizens. Because of this reason, the petitions were dismissed and the first constitutional amendment was held to be valid. Though it affected and altered the basic structure by taking away judicial review, in the year 1951 it was not declared to be unconstitutional, as the argument of basic structure of the Constitution was not considered in this judgment. The judgment of Shankari Prasad Singh Dio was ultimately overruled by the judgment of I.C. Golaknath by the Supreme Court in the year 1968, and which was again overruled by a 13-judge decision of the Supreme Court in the matter of Keshwanand Bharti. I will be dealing with the other judgments in other videos.